Well, all right. We are here, episode 31. I think this may be episode 31, part A. I'm not sure, but I think so. Let's go with that. Of the Burress Law, Life, and Friends podcast. We can't seem to stay off a dry dock, but nonetheless, we're back at it.
Well, what I would say is it is a rare day where we're both dressed appropriately in coats and nice shirts. We're usually much more dressed down. And we actually did wear this all day. Like we didn't put this on for the podcast. This is what we wore today.
I had a hearing and you had
depositions.
Okay. So that's why we can't get off the snide. Can't get dressed. So these are hard-hitting podcasts, really educational podcasts. I think both of them or all four of them, whatever you call it. But what we're doing today, so I get asked a lot, I don't know about you, but like, how is it behind the scenes? Like we see the pictures of you and your clients and we know the checks can be really big and the payouts can be big. But I mean, like, how does it work? You get that question?
I do. I get it from a lot of people that just don't understand the process.
Yeah.
And what it's like to have to fight insurance carriers on behalf of victims day in and day out, because it's not the same day every day.
That's right. And so I think part A of this podcast is let's kind of go behind the scenes of how a case works, how it, even before we sign it up, kind of how it works. And I think it'll be educational for people too. I would say 9.5, if not 9 3/4 out of 10 people will be in some sort of personal injury incident, whether it's a car crash, a truck crash, a dog bite, something in their lives. And I think it's super helpful for you to know what are good practices, what are bad practices, and how the cases work and so forth. Would you agree?
I would absolutely agree.
Okay. So let's start before the initial consultation. So every now and then, some like happened earlier this week, we have somebody who just drops by and I'm in warm-ups and you're barely beating me.
That's right. We usually get a phone call.
Yeah.
And what I do like about the area we're in and the people we get to serve is, I would say the vast majority of people that call have done some sort of research already. They figured out, I don't want to go with these attorneys or those attorneys. I want to try and go with Burress.
Right.
But we do get the drop in. Got it this week. I don't like the drop in. For a lot of reasons. One, I'm not prepared for that meeting. I mean, you're walking right up to me and I don't know, I'm learning on the fly about your case, so I don't like that. The other thing I don't like is there's a decent chance some of us aren't going to be available to meet with you if you just walk in. You may not be here. I may be tied up in depositions. Brian could be. There's all sorts of problems with just popping up. But all that said, if you're going to pop in, and we'll figure out a way to make it work.
That's right. But mainly, just put our name and the number 214-726-0016 in your phone. If anything happens,
that's right.
Call.
Yeah.
We're
available 24 hours a day.
That's right. It makes it hard because, from our standpoint, there's certain cases that you would deploy a particular team on,
right.
Attorney, paralegal, legal assistant, and you have to go with whatever is there right then.
That's right.
And that's okay. But usually we get a call. But let's talk about I think the best thing for the viewers or listeners, what causes us not to offer our services on a personal injury case when we get that call or that drop by?
Well, I think my mind works in steps always. It's just the way I keep things organized. And the first step for me is, do you have a case, right? It may be shocking to some of our listeners, but just because you were injured does not mean you have a case against someone. There's a wealth of law on slip and fall matters, right? There's a wealth of law on animal matters. We've had cases where people were injured by horses, and if you're not up to date on the farm animal statute, you may not realize, okay, so do you have a case, right? If you don't, I'm not going to offer my services. From there, it just becomes really to answer one question, but it can be answered no for a number of reasons. Is it a good fit, right? You don't want to take a client that's not a good fit. Clients don't want an attorney that's not a good fit. And that can be for any number of reasons, right? The amount of time that's gone by since the event happened until when you come and see me. What have you done in that time? Have you damaged your case, hurt your case? There's just all sorts of reasons.
Yeah, I think the time between the incident and the call or contact is probably the number one thing. And I think that's the number one thing that potential clients have no idea.
Right.
They don't seem to think it's a big deal if they call you a year and 3 months after the incident occurred, because they've already gotten the police report, they've already gotten their treatment done, they have already established a relationship with the insurance adjuster. They've got it all figured out. They're just handing it to you, but right?
Right. And on the time thing, what I tell people all the time is there are tools that I have to make your case the best it can absolutely be. And the longer you wait, the more tools you're taking out of my chest to make it more difficult for us, right?
Right. Every morning we have a PNC meeting, potential new client meeting. We go over all the new clients every morning. And I've been doing this on this side for nearly 18 years, and never once have I said or have anyone else said, man, I am really glad that this potential client handled this case on their own for X number of months or a year
right.
or whatnot, right?
Yeah. No, waiting is never the answer.
They are going to mess up their case. It's just as plain
100%.
and simple as that. And it is to a person.
Yeah.
It will mess it up. I think the next thing that I think of is we had one of these earlier this week, the potential client who is so cocksure about their case. Their case is the best case ever. And that when I hear it's a slam dunk, right? I want to run.
Yeah.
You?
Yeah. You know, the way I say it is people, it's personal to them, and it should be because it's their case. But you're not going to look at it through your eyes. You're going to have juries looking at it through their eyes, the story being told. So it all makes sense. And I really touch on it more when we're prepping for deposition or something. I go, don't go in there and try and convince them because you feel like no one's told your story. Your story's been told. They're just looking at it unemotionally.
Another one is the expert legal researcher. Like they have looked up how it works and they get 3 times the medical expenses and right?
You get that. I have had to beat that. I've had to bring people in and open up the rule books to them and show this is the rule. Like I don't know what the internet's telling you. This is it.
We just resolved a case for, I think, $756,000, and it was about 12 times the medical expenses. So in that case, and there are those cases where they're just a multiple of the medical expenses, but then there are other cases that may be very well handled, and they may be 2 times the medical expenses.
Right.
It just depends. It depends on a large variety of factors, but there is no multiple that you can count on in a case, and that's
right.
As simple as I can put it.
Yeah, people used to hear a third rule, 3 times rule, whatever you want to call it, and that's just not. It hasn't been like that in 20 years.
Yeah. The demanding potential new client, right? That exists.
That does exist. I've had potential new clients where I did not offer my services because they came in and said, I only want to talk to you. And I was like, that's not going to work. We got a whole team here, a very talented, uber talented, the best team in Collin County. And I can't spend all my time on your file. I got to work all my files.
I need to say at this point, the best team in Grayson County, the best team in Fannin County, the best team in Lamar County, and county after county. I think we are definitely the best team. There's some really good firms in Dallas that are good friends of ours, like Payne Mitchell and others. But up here, we're it's a It's a one-horse race.
We are the masterminds of Collin County.
That is right. That's an inside joke. I like that. Yeah, we don't have to do mastermind classes. We don't have to do that. You do. Yeah, I mean, the demanding, I get that too, right? I only want you to handle my case. I'm like, no, you don't want me doing your intake.
Right.
Trisha's going to be far better at that. And it may be, it just doesn't work like that. We've got a whole building full of killers, and we like to decide who we want to deploy, what team we want to deploy that we think is right for a particular case. And that's not always me, for sure.
Yeah, me either. I mean, I think there's cases that, I'm the perfect fit for, and there's other times I'm like, that makes perfect sense to go to.
Yeah, and I really think we know that better than anybody else. Like, we can evaluate it and know which team is going to be a great fit. The other one, we have a really different philosophy than other firms. And remember the one time that we had a consultant come in and check us out, and what did he say? One thing.
Yep.
That he didn't.
I had the way we select clients, intake clients, is what you're touching on. And I had a attorney in Dallas that I was talking to about it, and he goes, I don't want to tell you you're doing it wrong, but you're doing it wrong. I was like, we are not doing it wrong. We're doing it 100% right. It's just different.
Yeah, this hotshot consultant came in and really liked all of our processes and systems and everything that comes in between and outside of those parameters. But the one thing that they all hated, that whole consulting team, was our intake process. Yep. Their philosophy is you sign clients up as quick as you can. Right. You don't need to meet them. You just send that contract out, and by DocuSign, you get them to sign it. You worry about the rest after that. And that's that. There's no embellishment in that statement. That is what they said to a T. And I looked at him and said, we could not be more different on this issue. And we are so comfortable in our the way we do things, because we use that intake process as an opportunity to get to know the client and see if it's a good fit.
Right.
And one of the things that you get to see is that client responsive? When you say you need these 4 documents, does that client get you all 4? And then say, is there anything else I can get you? Or do they give you one and say, I'm tired of talking to you, paralegal. I want to talk to Burress or Hejl or one of the partners or whatnot.
Right.
We learn a lot during that process, and we learn if we're a good fit.
It also helps, one, like you said, to kind of learn a lot. And I'm going to segue into the next topic, which is the intake meeting. But it gets you prepared. Like, you already know if you think they're going to be a problem with responsiveness, if they don't have the stomach for the fight to go all the way through. You can learn some of those things just by how responsive they are.
But I think part of it is just having a moral compass. I do not want to sign you up until I have the requisite information to believe whether or not you have a good case. I want to know that before I offer our services. I don't want to not get any information, get you signed up on our fee agreement, and then tell you, hey, by the way, your case is not. I don't want to do that. Why would we want to do that?
Yeah, there's no reason for that.
Maybe we lose some cases that way. I'm totally comfortable with it. For me, I like our process.
Agreed.
So we get past the call or the drop by, and we have the initial consultation. Some people have asked, what happens during that first meeting?
That is probably one of my favorite things that I get to do. It's a meeting where I walk in, the team that's been assigned to the file, the case manager, paralegal, whatever you want to call them. I'm not big on titles. People can call themselves whatever they want. We're all teammates here. And so it's a minimum of 2 hours of walking them through, learning about the case, letting them learn about the firm, about us, about me, and then getting them educated on what the process looks like ahead and moving forward. I always tell them, and I did one yesterday. I said, I don't ever want you to feel like you're on an island out there and you don't know what's going on. The other thing I don't want you to feel like is you're on this long march and you don't know if you've got 5 yards or 50 yards or 500 yards to go. That's a terrible feeling. And so let's talk about what's going on, what's going to go on, and get you so you're in the boat with me rowing in the same direction. And those meetings, I think, are just invaluable. I mean, I come back to that meeting all the time. You know, an issue will pop up in a case, client calls in, and I go, remember when we talked about this when I signed you up? Remember that? And they all, I doubt half of them do remember, but they do go, yeah, I know, I do remember that, you know. And sometimes they're like, yeah, you told us this was going to happen or whatever. But it really lets you get to know the client, let the client get to know you so you can build that relationship and then get them where their expectations are where they need to be.
Yeah, I mean, I always say what we're doing in that meeting is we are teaching you how to be the best potential partner to us in your personal injury case. And part of that is teaching you the tricks of the trade. There are 20 do's and 50 don'ts in this business.
That's right.
And you have to know them and abide by them in order to be a great partner. The other thing is, this is not a, one solution fits all problems type thing.
Right.
Like, this is a deal, like, you have to listen to the client, you have to understand their story, and you have to build a strategy around that client, those injuries, their story. Right. And that you can only do if you spend the requisite time doing it. Nothing, as you know, will grind my gears faster than a new attorney, or a new paralegal, and they try to get out of that meeting in an hour and 40 minutes. It drives me completely crazy because I know there's 15 or 20 minutes that could have been spent to teach something to resolve an issue that, or never to have an issue come up later on if we would have done it.
The one thing I would say about it is the poor teammates that go in there with me have heard me do it over and over and over again. And I tell the same stories because that's how I build the relationship. And everybody in this building knows my mom had the beauty salon back home because I mention it every time there's a sign up. But I think it's just important to build that relationship with the client, and that's how you start it.
Well, but that's how we all do it. I mean, if we're mediating with, one of my favorite mediators, he's going to tell a story about trying a case against me. He's going to be telling a story about, his practice and where he came from. And that's just the way you do it. And part of it, you have to have, you have your own story, and you don't need to make up a different story every time. They need to know who you are. And most of us can really tell them who we are by just telling that natural story that comes out. They like it. If they don't, then that's okay too. Okay, so we get them signed up, and then we have the medical treatment generally. Once in a while, medical treatment's concluded. Usually when they come to us on the front end, and they do, then they're going through that medical treatment process. Do we send them to certain doctors or medical providers? No. Do we help them when they otherwise probably wouldn't be able to get treatment? Yes, we do. So there's a bit of a fine line in there, but I'm not telling them, you must go here, but
yeah,
that makes sense.
We definitely don't do that. And it tips the apple cart because there are firms that do that. Dallas has PI firms that have a bus that will go around and pick their clients up and take everybody to the same chiropractor. We just don't do that. We don't.
It's a bad practice.
It's just a bad practice.
But by the same token, so many of our clients cannot see their own doctors. One of the dirty little secrets in the business is that 90%, if not more, of your primary care physicians, your family doctors, they won't see you if you've had an accident, a crash. In fact, it'll be on their questionnaire. And as soon as you do that, they'll tell you, we can't see you because it's a crash case. My doctor, Jeff George, he's one of those. I quit him for several years. But it's irritating to me, but they don't. But here's the other secret. You probably don't want to be going to your primary care physician anyway in a case like this. There are pitfalls
There's a lot of pitfalls in your primary care physician is great for what they do, but this isn't what they do. Yeah. And the advice that they give on how to treat some of these injuries, especially someone that may have a minor TBI, something like that, you really need to get into someone that deals with these types of traumatic events.
Yeah. One of the other things that happens, and I think most people don't realize, is my father-in-law and brother-in-law a couple of days ago sent a trucking case to us, really bad trucking case, lots of injuries, lots of surgeries. And in a case like that, a day went by and we didn't get a call, and we were supposed to get a call. And so then my father-in-law reached out, "Have you got a call?" And I said, "No, they need to call now."
Yeah.
Because in some of these cases, and in every trucking case, preserving evidence is so important. So one of the things we do in those bigger cases, especially if we think there might be a liability dispute, but in a trucking case, we're doing it anyway. We're deploying our accident reconstruction experts, a whole team of experts, to make sure that we scour the scene for physical evidence, witness marks, tire marks, brake marks, photographing and taking measurements of the vehicles, and just evidence collection. And if you don't get a call or you don't get a team deployed, I mean, your case is not worth nearly as much. So what we're doing in those early stages, we are developing evidence or securing evidence, talking to witnesses before they run off and we cannot find them. And all those things strengthen the personal injury case.
And one of the big things I would add on to that is trying to acquire video of the event.
Oh, yeah.
It is, from when I started practicing to now, it is night and day about how often you can actually get video from a Ring door camera, from a business that has, security outside. But those things do flip over quickly. And so there's been times where they're like, yeah, we absolutely have video of that intersection, but we deleted it 48 hours after the event happened, or after it's important to get on it fast so you can get that evidence in.
And then the evidence preservation letters with instructions to the trucking companies of what categories of documents to maintain and not throw away. And that gives you a lot of power later on if they do break that spoliation rule. There's been some case law that's undone a little of that, but it's really important. And so we get through, the client sort of gets through the treatment process, and sometimes they're done treating, and then sometimes they're in more of a maintenance mode a lot of times, and sometimes they're going to treat for the rest of their lives.
Right.
Ultimately, we get to a point where it makes strategic sense based on the case, usually to send a pre-suit, before we file suit, a demand package or demand letter to the insurance companies.
Yeah. And our demands are just phenomenal. Yeah. I mean, and it's the effort that goes into it, the work that goes into it, and a lot of hands touch it. So it's not Kyle or Brian or Jason sitting down and, writing a demand. It used to be. It is not anymore. But we do a lot of things. One of the things that I think is just outstanding about our demands is the use of photos. When you have a photo of the person on the demand, it makes it more personal. It makes you realize who you're working with. When you see medical illustrations, when you see procedure illustrations, you can talk about a disc herniation. You don't really know what that looks like. Well, here's what it looks like. You talk about injections. A number of our clients receive that type of treatment. It's not a flu shot. It's a big old needle going right into your spine.
Oftentimes you have to be placed in an unconscious state.
Right. And I think I'm a visual learner. I think a lot of us are. And so I think our demands with the photos that you get, the way it's put together, it's eye-catching. As a guy who was on insurance defense side for 12 years, I know that Friday afternoon at 3 o'clock, it's a white sheet of paper with black letters. And you get one from Burress, and it's going to make me sit up and pay attention.
Yep. And I get appointed as a guardian ad litem on a lot of cases. What that means is I'm the third-party attorney looking at a case that we haven't handled.
Right.
Another firm has handled generally, and we're looking at it. And I got to tell you, the average demand that I get from those other lawyers is 2 pages.
Yeah.
And our average is more than 25.
Right.
It's a huge difference.
It's a huge
I mean, we include every diagnosis code, every symptom, every physical impairment, every medical, Excel spreadsheets. And then, we also talk to the clients and visit and have these strategy meetings to see, are we effectively telling your story? How can we tell it more effectively? And that is worth its weight in gold.
Yeah. And I tell people all the time, the demand is one of the first times that I get to start really advocating on behalf of the client. Now, it's written, but it's still me advocating and talking about how the injuries, how the pain, how the problems, the complaints have negatively affected your life, right? Because you used to, have these active hobbies or whatever the case may be, or spend time with your grandkids, and now, you can't do it anymore because of the injuries. You can't put in the kind of time and it's really negatively affected your quality of life.
Yeah, those demands are important, even down to, I'll tell you, for me, it's even down to the bottom of the page where I want it to say page 1 of 27, page 2 of 27. And I don't want it to say page 1, 2, and 3, because then if page 27 is missing, they don't know it. And page 27 is a really important page on the demand.
Yes, it is.
So every little detail at this firm matters, and it always has mattered. And that is the secret about the demands at Burress Law. And then we usually have a negotiation process with the insurance company. Sometimes that involves multiple insurance companies, and sometimes it involves one. Sometimes it's the insurance company turning over the policy.
Right.
Sometimes it involves multiple policies with each carrier. And you're not going to know that unless you have a qualified personal injury legal team, right?
Right.
You're going to know if there's 1 or 2 or even 3 policies.
Right.
But there's usually going to be some sort of negotiation process. And are we in the business of trying to secure a fair compensation?
No. I don't want fair.
I don't want fair either. Nope. I don't even like full. I like very full.
That's right.
I like cup runneth over full, right?
Yeah. Mincher's quote that's on the back of the T-shirt of, what was it?
Breaking necks and cashing checks.
And Kyle Hejl's is, it's a sin to let a sucker keep his money.
And I'll just go with Ellis, TCB,
That's right.
Taking care of business. Yeah, I mean, I think another question we get a lot is, hey, does this money come out of the responsible party's own pocket? The answer, sometimes.
Yeah.
Sometimes you have a wealthy individual or an individual who has assets that's not his homestead or his primary automobile, and they didn't carry enough insurance. And do we get them? Yeah, we do.
Yeah.
Usually it's the insurance policies that we're dealing with.
Yeah, the negotiations are fun. I've always enjoyed negotiating, and so I want to dispel the one myth, and I may be getting ahead of ourselves, but insurance companies don't just settle.
No.
They don't just pay claims. You have to go and really work at it. That's why we have a job. So
100%. So sometimes maybe, I don't know, I'd have to look at the current percentage, but I could spitball it and say low 30s%. The insurance company doesn't do the right thing, or one of them doesn't do the right thing. Right. And we have to file suit, right? And like we're going to include the client on those big strategic decisions, right?
Right.
Whether the case resolves, whether we're going to file suit. In 17 years of doing it on this side, I can't remember more than a couple where there's been a significant disagreement. And I think part of that is that initial client meeting where we get their buy-in to, hey, they're not going to pay full compensation for the claim. Are you willing to let us file a lawsuit? And if they're the 1%er that says, no, I want to take whatever their best offer is, then we are 100% not the right firm.
Yeah, and it does absolutely go back to that initial meeting, and making sure they're involved in it. And the way I tell them is, we have built a reputation of not taking bad settlement offers. Okay, you are getting the benefit of that because of all the clients that came before you. All I'm asking you to do is toe the line. Don't take a bad settlement offer, and trust me to handle the case.
Yep.
Because somebody's going to come after you, and then if you take a bad offer, they're going to expect me to do it again.
And typically by this point in the case, the client says things like, Jay, I have a 100% trust in this team. I will do whatever you say.
Right.
And I love that because it gives me a lot of control in that process.
Right.
I'm not fighting a two-front war with insurance
Right.
company and client. I know my client will let us file suit. We'll try the case if we need to. And there's a lot of power and leverage with that ability.
Yeah. No, I love it. I love every time I pick up the phone and I give this long-winded explanation of what we should do, and the client gives me about a 2-second response of, well, I trust you and I hired you, so go do what you think is best. And I'm like, okay.
And then sort of wrapping it up, if we have to file suit and we start the litigation process, there's a lot to it, right?
Yeah, ton.
What I would say, in the way I described this, so number one, we had to have a lawsuit in my family's claim from a few years ago. And what blew my mind, as long as I've known my wife, and Tricia sends her a copy of the lawsuit, just like she does everybody else, and my phone blows up, and I didn't answer. I finally get home, and Christina has her hands on her hips. Just picture this. She's like, cannot believe that we have to go to court. Cannot believe it. And I was like, well, I didn't know we had reached that point. I thought we had just filed the lawsuit, and there was still a 93% chance that this case resolves peacefully. Well, I mean, I just got this in the mail. I understand that. That's a petition. That's a lawsuit that's filed. That doesn't mean
Talking to you for years, sweetie. You're not listening to the word I'm saying.
But we joke about it. But the truth is, when you file suit, I'm telling you, half or more of our clients think, oh no, this means we're having to go to court.
Right.
But it's
another topic I try to educate them on in that first meeting.
Yeah. But handling your claim pre-suit is horrible. That's a terrible thing to do. Trying to handle your claim in litigation, I don't know that I've ever seen it in a personal injury case, but it would be a terrible move. You've got discovery, including depositions and written discovery and all these deadlines and rules and offers of settlement and mediation and preparing for trial and exhibits. Can you imagine? It would just be impossible.
Well, and what I would say, I have seen it. I have seen pro se personal injury litigants, and it's the circus that you're describing right now. It's awful. And most of the time, even pro se with a valid claim would trip up somewhere, would just get out lawyered, right? And so I would definitely tell people not to try to do that.
The other thing I would tell people, when we file suit, we're going to be doing 95% of the work. You're going to be doing 5% or less. We're going to prepare you for your deposition if we get that far. We're going to prepare you for the mediation, but we're filing all the paperwork. We're doing the heavy lifting. We will use you as little as we need to,
right.
but also as much as we need to guarantee a great result for you. But I think there can be a little bit of a misconception sometimes.
The other thing I would say real quick about trying to handle it yourself, insurance adjusters will flat out tell you things that are untrue about the law because they tell them to me, and I'm like, that's not the law. That is not what the law in the state of Texas is. Mm-hmm. And they're like, it absolutely is. And I'm like, well, you're an idiot.
And then to kind of shortcut it, if we do have to prepare a case for trial, by that point, I usually find that the clients are totally on board with it. They have seen the inner workings of the case. They've seen how the insurance company has treated them, even with us representing them, and they are ready to go get them. And I find that we have really great partners in that point of the case. If it gets that far, less than 10% get that far, and they just work together to create the strongest case possible. And we spend a lot of time with our clients. Again, that is different than many, many other firms where you guys worked, you and Brian and Griffin and others. I know we do that differently, but we spend a lot of time in that prep portion.
Right. Yeah. Man, once we get to trial, getting the client ready and getting them comfortable, and one of the things we do, and Judge Tom Novak was telling me I didn't do this, and I go, I absolutely do this. If we're going to trial, I take them down to the courthouse, show them the courtroom. You shouldn't see it for the first time when you walk in to go pick a jury. Get a little comfortable with where you're at. So
yeah, for sure.
But yeah, I've in my experience, we've had wonderful clients that trusted us, did everything, stayed late, whatever we needed to make sure they were ready.
Yeah. And then finally, the good thing for clients is when, the 92 or 93% of these cases resolved without the need for a trial, everything is automatically done, and the next day you get the settlement money. That's am I understanding that right?
That's not how that happens. Yeah, shutting down a case is an art, not a science. You've got a lot of things you're dealing with. You're dealing with paying back medical providers, outstanding balances, verifying those balances, getting the settlement documents in from the insurance company, getting the check in from the insurance company. And for you guys that don't know, the checks can come from anywhere. I mean, not every major insurer has someone cutting checks in Dallas, Texas. Sometimes they come from Utah, and they mail them. And it is shocking how often something gets lost in the mail. And when that happens, you have to put a stop payment on the check. And it's a nightmare. But shutting down a case is probably my favorite part, I think, just because I really love attacking medical providers that are being unreasonable, which we have from time to time, that are greedy, that are trying to take more than what is a reasonable, fair payback rate. And I love going after subrogation holders.
Yeah, and so what that is, subrogation, think of a health insurance carrier, most probably a health insurance carrier, health insurance company that has paid claims-related treatment. So they have paid money for your treatment that is related to the incident for which we're representing you. Subrogation is a legal concept that allows them in many circumstances to have a right of recovery out of your settlement or paid judgment. We love to attack that. I think of everything that we do, I think we are so good at that part of the case, far better than anybody that I know of. There's a lady in Austin who's an absolute expert at this, so maybe save her. But I love that part because the attention that we pay to these details,
right,
on what I call the backside of the cases, results in about a 75% reduction in medical bills and subrogation interest and lien interest. And that's a phenomenal percentage. And
right,
every dollar that we save the client, that whole dollar goes into their pocket. Right. And it's huge. And the reason why I think we're so unique to most other firms is they don't put the emphasis on that, right, because they don't get paid for it.
Yeah. In that scenario, when we're attacking those holders, as you said, every dollar we save goes into their pocket. I'm not generating any attorney's fees for doing that work. That's just for the client's benefit. And that's why I think I love it so much, because if you make a $20,000, $15,000 difference, that goes directly to the client.
And it's an easy thing for us to buy off on, which is why we always have. Yeah, we're not making a fee off of it, but who cares? We are earning a fee by representing you, right, in this personal injury case. It doesn't stop until we're done.
Right.
And heck, we're here after the case closes. If anything comes up, if any provider says, we didn't get a check, or we can't find it, or whatever the case may be. But the other reason is there's such a direct correlation between doing a great job once the case settles, where you get the judgment, to the point where you're dispersing the money. Doing a great job there leads directly to enhanced client satisfaction. And who wouldn't want to be a part of it? I'm not doing this simply for money. I'm doing this because it matters to me that our clients think the job that we did is excellent, and they go tell their friends and family, and reputation matters. It just cannot be all about the dollar.
And how many times do we have a referral? So-and-so told me to come see you. And that's why, because it's the passion and the excellence that we put into the work.
There you go. I think one of the most, educational topics that we've hit on, and I hope that you all find it interesting. We certainly enjoyed bringing it to you. So again, thank you for tuning in to episode 31, part A of the Burress Law Life and Friends podcast. We'll see you soon.